Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, what we're going to talk about on this episode of The Bullet Points is going to start your week out right, and I think it's going to leave you with a smile. The ATF has been dealt another blow on their interpretation of receiver rule as it's gone forward and gone through the court system. Now, about a month and a half ago, we covered a case called Vanderstock versus the ATF, the DOJ, Merrick Garland, and Steve Dettelbach. Okay, that's the long case name. But essentially in that case, the ATF was given an injunction to say you cannot enforce your new receiver rule because it's going to irreparably harm this company, Tactical Machining. Well, there is a development. The original video is linked in the description box below if you want to catch up, but now this injunction has been expanded by the same judge to cover all of their customers. It doesn't take long and take a whole lot of optics to understand the importance of this extension. Like I said, check out the original video. I'm going to say a quick word from our sponsor, SDI, and then we're going to dive into it, and I cannot wait to show you a few of the clips from this most recent ruling released October 1. Now, I know a lot of you out there like to upgrade and repair your own guns. If you're looking for a way to take your hobby to the next level, Sonoran Desert Institute can help you do just that. The online programs at SDI cover armor courses, gunsmithing, ballistics, woodworking and finishes, shooting sports management, and more. Plus, all the tools and materials are shipped directly to your door. There's never been a better time to turn a hobby into a career, so what are you waiting for? Check out the link in the description box below, and thank you so much to SDI for making the videos possible, and I can bring you this content. So as I mentioned in the intro, guys, we are talking about an original injunction that was given to protect Tactical Machining. They produced 80% lowers. They were basically going out of business because of the ATF's new interpretation of existing law. If you recall in that original video, basically we covered the idea that this injunction implied that the ATF was superseding their bounds through the Gun Control Act of 1968. They went too far. The judge is not done. Listen to this. I cannot wait to hear what you guys think. So here's the case in question right here. You've got Jennifer Vanderstock, Michael Andren, Tactical Machining, and Firearms Policy Coalition are the plaintiffs. They're going against Merrick Garland, that's the Attorney General, United States Department of Justice, Stephen Dettelbach, the ATF, all of the different pieces that are enforcing the new receiver rule. Of course, we know this is a cluster beyond clusters, but now they're getting injunctions, and the injunctions are expanding. Check this out. I am amped to show you this. Here's the backstory. If you didn't want to watch the video, I have linked in the description. On September 2, 2022, this court issued an opinion and order on preliminary injunction relief, granting in part plaintiffs' earlier request for interlocutory relief. In that opinion, the court invited the parties additional briefing on the proper scope of the injunction. Before the court are plaintiffs' request to expand the preliminary injunction. That's what we're going to talk about right now. They're trying to expand it beyond just tactical machining and go and cover the customers. That's the important part. So if you're a customer and you were going to buy a lower blank and you didn't want to do it anymore because you were afraid of criminal penalties, that's what this injunction is addressing. That's really important because if you take that across every other case, you can see where this goes. But let's continue. Here's some more background that the court provided. The United States Congress has delegated the Bureau of Alcohol, Tobacco, Firearms, and Explosives authority to regulate firearms and interstate commerce under the Gun Control Act of 1986. That's the whole point of contention. We're going to come back to that. In April 2022, the ATF promulgated a final rule that purports to regulate partially manufactured firearm parts and weapon parts kits. Plaintiffs brought this suit to challenge the legality of the final rule. That's what the entire point of this whole lawsuit is to question that. Did the ATF supersede their authority in the 1968 Gun Control Act, going beyond what Congress delegated them? That's the important piece here. Let's keep going. Here's what happened prior. In its prior opinion, the court found that provisions of ATF's final rule likely exceed the scope of ATF's authority under the Gun Control Act. Having made this preliminary finding, the court enjoined defendants, including the Attorney General, Department of Justice, ATF, and the ATF Director, along with everyone who works for him, from implementing or enforcing that rule against only tactical machining. That's the whole point. They protected tactical machining, but now we're going in and broadening to the customers. Again, I'm going to hit that point a lot. This is important because if it goes national in this exact same scenario, this final rule is going to go away real quick. But let's keep going because this is where it starts to turn on the new request. Plaintiffs now seek to expand the scope of the injunction to cover individual plaintiffs, FPC as an organization, and FPC's members. Plaintiffs also request injunctive protection for Tactical Machining's customers, which they say is necessary to afford Tactical Machining complete relief. Absolutely correct, because if the customers are afraid they're going to go to jail for buying something from Tactical Machining and the rule is in question, that applies that injunction. That's where we're going on this, and this has so many legs, it could go really great places for us. The defendants, so this is ATF and DOJ. The argument also misunderstands Tactical's alleged harm. Even if Tactical did resume selling those products altogether, Tactical's customers are clearly afraid to buy receivers with or without accompanying equipment, absent an assurance that they will not be prosecuted for their purchase. And, as previously discussed, this part right here, defendants offer no such assurance. You are punishing a company by not offering assurance to customers who would partake in their product. That is a bit of a problem, particularly since you've already superseded the authority given to you in the Gun Control Act of 1986. That's a big one. The court is onto something here. Oh, let's keep going because it only gets better. Defendants' arguments are wholly unpersuasive. That's what that means. Thus, the court is satisfied that customer concern over civil and criminal penalties must be alleviated to provide Tactical Machining the relief it is due. To accomplish this, the court finds that Tactical Machining's customers must be covered by the preliminary injunction. Translation: the customers are now covered by the same injunction. You apply the same principle, the same logic, and the same precedent across other cases as this continues, you can see where this goes. This final receiver rule that Biden has touted so heavily, it's not as strong as they want to let you believe. But here's the last piece, and this part is delicious. This case is still in an interlocutory stage, and the court has made no findings of the final rule's illegality. No finding of the final rule's illegality. It has merely held that the rule likely exceeds the scope of the ATF's authority under the Gun Control Act. Even they're saying it in the ruling. This is the judge writing this. For the foregoing reasons, the court declines to broadly enjoin defendants' enforcement of the final rule and finds that the appropriate course is to extend the preliminary injunction instead to only those plaintiffs who have adequately demonstrated their needs to be included in the scope of expanded relief. Individual plaintiffs, Tactical Machining, and by necessity, Tactical Machining's customers. That's incredibly important because it is expanding across the board. The walls are closing in on the ATF's final rule here, and even this judge is saying just such in this decision. And here is the actual signature. So ordered this first day of October 2022, Reed O'Connor, United States District Judge. This is something that we're going to be continuing to be covering. This is a really big deal as it expands and covers because this directly aligns to our rights as American citizens. Thank you so much for watching. Let me know what you guys think in the comments field below, and I will see you tonight on the next episode. I'm Braden. See you later.